The next topic I want to cover is drafting of the claim or the defense in the small claims court. So in this particular part of the seminar, I want to just make a couple of points about the drafting issues. Well, the most important point I want to make is that in any litigation in the common law system is identification of the party that you're dealing with. In other words, the legal entity. And there are only basically two entities that the law recognizes. One is a person who is a mentally competent person, and secondly is a corporation. And these two legal entities have to be identified correctly. I've seen in my experience as a deputy judge too many times that the people who are litigants do not make sufficient effort to identify the parties. A best example is that you're trading by a trading name, ABC. You brought the name there because that's the name that the person had on a business card. And you saw the same name in his business premises on the top of the store where you went, or in the letterhead. And therefore the assumption is that that is the legal name. Very often it may be different. And there are many numbered companies that you may have in which there's a trade name, the numbered company, and a person who may sometimes use a different name. I had the occasion recently drafting a claim in which there were at least 3 or 4 numbered companies, all of them with a similar name, which you can never remember, and then some very, very long names which people abbreviated because they were using long names, and these names are very hard to remember. But it's very important that if you're drafting, for example, a pleading, that you have a way of creating a working memorandum where you write these numbers down and do check and recheck when you're drafting the pleading. But even beyond the pleading level, before you reach that point, I strongly recommend that when you have a name, an entity that you're unsure about, then there is a method of finding where the details of that company. And that can be found at the Ministry of Corporate and Consumer Affairs, and there's a 363 University Avenue where you can do the search of a company. I think these are now possible to be made through companies which are private, called Cyberban, and other companies that will actually provide the details of the so-called corporate profile, from which you can identify the name of the company. And if the person is using a name which is very long and they've abbreviated name, then you should figure out the proper name by asking the question and investigating if required, because once you have started the claim or mostly a claim and the name is incorrect, then amending the claim is much more difficult, and it creates a legal problem also at the tail end of the action, that even if you got a judgment and the entity that you described, either through a wrong number or a wrong name, cannot be enforced by the sheriff for executions, etc. So the most important thing that you can do is to identify the party, and the party, if it's a company that you've researched and found out where the head office is, who the directors are, so that when it comes to serving that claim, you're sure in your mind that the correct party has been named in the claim. So in terms of the next step in the process of drafting is the question of the form. Now, in the small claims court, the whole procedure, because a large proportion of the population very often comes to the court without a lawyer or paralegal, then it has been formalized in very detailed forms that there are actually. Some of the forms I think we might go through on the screen to show to you that the forms are there and required to be used so that you can fill out the blanks and, and you can complete the form in the correct fashion, because if you don't, then the clerk in the small claims court will not let you file the document properly. So these forms are now available on the website. The number of websites of the ministry that you should get to know, from which you can find the form and make sure that you know how to complete the forms. And because the forms are a little bit more, so to speak, fixed in the way they are drafted, sometimes you can have an error made because you need to add a second page to the style of cause. When you added a party and they're the lawyer, there is a place for the party to be identified, place for the lawyer's name, their phone number, and all the details. So it's very important that the forms be completed in a thorough fashion, so that all the practical details that you need to write of communications and the parties in what is called the style of cause are correctly expressed on the correct form, and these forms are then used correctly before they're filed. And I gathered recently from our friend also that these are now capable of being uploaded directly in the court offices if you're familiar with the procedures also. But the forms must be the right forms, and the basic forms that you might need in a typical action include the form for claim, form for defense, form for motion, and even a settlement form if you're going to settle the claim in a settlement conference. So I think that the proper use of the form is very important. After you get past the form, the next issue that you have to deal with is the legal cause of action. And here I want to make an important comment actually, that the cause of action is what we're dealing with. That's why we go to school. That's why we have the practice. We are lawyers or paralegals who are advising the parties what is it that you can bring to the court and what is the law that you can apply in persuading the judge to take your possession with the law and the supporting evidence. So in terms of identifying this issue is, as you probably would know, is a cause of action. The understanding of the cause of action, or rather the reason for bringing the action into court, is fundamental. I have seen many times where in a situation where the parties simply narrate the whole story or several pages, this happened, that happened, and this is what things were like, but all of it is not necessary if you can exercise your skill properly, understand how to describe in basic words the cause of action, and supporting affidavit, evidence of what is that you went through. For example, you're dealing with a breach of contract situation. So you say the contract was written on this day, that you were supposed to perform some services, you didn't. On this particular day, you left the premises, you didn't show up, and didn't finish the agreement by finishing the work that you were supposed to do. Now that's a breach of contract, and you want to illustrate the cause, then a sufficient amount of information to support your position through evidence, and then you're not writing all the evidence in that pleading or in the claim or even the defense, but rather that you'll be putting that in another set of documents that you'll be filing with the opposing party. So how much do you write in the claim or the defense is a question of learning and skill, but essentially what you're doing is to summarize the story in the legal format, as I say, in the cause act point of view. And if you're the defendant's lawyer or a paralegal, what you're doing is to firstly pinpoint what the claim is about. Then what is your position as a defendant that you want to deny the claim? And at that time, having understood the plaintiff's description of the cause of action, you're saying that's not your position, but you have a different position. If you have a counterclaim, then you're creating a separate defendant's action and drafting a new claim, or rather defendant's action, in which you're saying that I have a claim against the plaintiff and possibly other parties in which you again describe your cause of action and then issue that separate defendant's claim. So to summarize, basically, I would say that one of the most important part of the pleading at that stage in drafting the claim of the defense is understanding and identifying your cause of action and defending the cause of action in the defense. I think one word of caution in terms of the negligence. I think the contract law and the law of the tort, which is negligence, are the most common forms in which we normally bring actions in the court. And when we deal with the issue of tort or the negligence, it's very important to understand that the negligence must be defined. So if it's a contract, I'm sure you know the principles. It's the two parties have an agreement, there is a consensus, consideration, and the terms of carrying out the terms of the agreement. If it is a tort or a wrongdoing in which a party was negligent, you didn't have an agreement. You created damages by way of failing to carry out your duty of care. So in a tort action, what you're looking for is identifying the absence or the negligent act that created the loss to you. So when you identify that negligent act, the negligence act was created to summarize or to explain what was it that happened and create the categories in which you describe that the person who was negligent in that they failed to do certain things, and that categories of what was done wrong have to be defined. This is very often missed out. So therefore, it's very important that you have sufficient understanding of the principle of negligence, and also important to remember there is not a question of either you are negligent or not negligent. The negligence can be a portion in terms of the liability between different parties, and you want to make sure that you describe that situation in careful detail in your pleading, so that so that the judge can understand, and the judgment can be made based on what you say in that particular pleading.